Good morning, everybody. It's spring, it's a beautiful morning, the sun's up earlier, footy's in the air, racing season about to start, and another magnificent Greens List seminar. Congratulations on all getting here so early. This morning we've got two speakers who are going to give you an update on serious injury decisions in the Court of Appeal. They'll be canvassing 9 in all. The first speaker will be Stephen Jurica. Stephen is a member of Greens List, obviously. Many of you will know him, you've briefed him or you've seen him in court. It's appropriate in a football final season to tell you that Stephen played football for Richmond, and I'm told he was a star in North Ballarat. Is that right? Did you play for North Ballarat? Hopefully you can still remember some of the fitness days. He's going to be talking to you about pain and suffering and loss of earning capacity cases, and after that you'll hear from Eitan Makowski. I'll introduce you to Stephen first of all. Thank you.
Thank you very much, David, and good morning to you all, and thank you for coming so early, and pardon the pun, hopefully it hasn't caused you too much pain and suffering. Now, as David mentioned, I'll be going through the recent pain and suffering cases and also the loss of earnings cases. And in that first page of our paper, we've gone through and highlighted the cases that we'll be talking about, and they're all Court of Appeal cases. So, with the first case of Halpin and Wilson Transformer Company, Proprietary Limited, that was a decision on the 28th of September 2012, and it involved an appeal to determine whether the trial judge misapprehended the effect of evidence. And this was an appeal from Her Honour Judge Kings, and essentially the appeal was allowed. By way of background, this involved a 74-year-old process worker, an injury to her rotator cuff, right shoulder, as a result of tripping and falling at work in February 2009. And this is a case where she continued working on the assembly in the respondent's factory. And essentially the Appeal Justice Osborne did say in the judgment that the trial judge misapprehended the evidence in 4 material aspects. The first was the injury due to the ageing process. Now, Her Honour unfortunately stated that both Ms Keith and Mr Shannon, the surgeons, accepted the plaintiff injured her shoulder due to only the ageing process. What actually happened was that the medical evidence was that the rotator cuff could have been as a result of either the ageing process or the injury. And neither Mr Keith nor Mr Shannon went on to say that the ongoing nature of the injury was just due to the ageing process. The second factor was that Mr O'Brien was the only doctor to consider surgery. Once again, that was incorrect. Not only did the treating ortho, Mr Colt, consider surgery, but also Ms Keith, who was referred on, and also 3 of the medico-legals, being Mr Breary, Shannon, Mr O'Brien, and they all said that decompression surgery may be appropriate. And essentially there was overwhelming specialist medical opinion that decompression surgery may become necessary. The third factor was that Ms Keith reported that pain had settled down. Now, Ms Keith reported the plaintiff said the pain had settled down a lot. Once again, that wasn't quite spot on. The evidence was that the severe flare-up of pain due to the repeat injection of the shoulder had settled down, but that the base level of pain was still there and that the appellant was still suffering from that. Fourthly, the fourth factor was that the appellant retained the ability to engage in moderate activities. Her Honour concluded that the appellant retained the ability to engage in moderate physical activity such as swimming, playing tennis and playing with her granddaughter. However, Mr. Colt did not say that the appellant had retained the ability to engage in moderate physical activities, but rather he would recommend she continue those activities subject to any restriction consequent upon the pain. So it follows that the Court of Appeal in this case showed that the trial judge in this instance misapprehended the effective evidence in those 4 ways as I've just mentioned. And the other point to notice also is that Her Honour failed to take into account relevant considerations, or Her Honour took into account irrelevant considerations, and accordingly her decision was vitiated by a specific error. A couple of bonus points I'd like to just mention also, that despite the fact that she continued working full-time as a process worker, she was limited by the range of activities she could undertake, and she wasn't able to multi-skill like she could before and reach at certain heights. There was significant evidence actually brought out as to her significant level of pain. Histories were consistent. The appellant gave good evidence at trial, and it was consistent with all the medico-legal opinions, so that was handy. And essentially the court held that the appellant should not be punished for her continuing to work and for her to be stoical in the face of pain. Moving on to the second case of Hawkins and DHL, Express Australia, that was a decision of earlier this year, and essentially it was an appeal about whether the trial judge erred in regarding the failure to take medication or continued treatment as evidence that the PNS consequences were less than very considerable. And here the appeal was dismissed, and it was an earlier decision by Her Honour Cathy Burke. To give you some background, it involved a neck and right shoulder injury. The appellant was 55 years of age, a driver at the Tullamarine Airport, and he injured his shoulder working and pushing and attempting to manoeuvre a loaded cage when he got sudden severe pain in his neck and his right shoulder. He did receive workers' comp, and that was ceased, and after a period of time he was on the age pension, and then after that his son-in-law arranged for him to do delivery work with ProAir Systems, and at the hearing of the application, the worker was 71 years of age. He was able to work at his own pace at ProAir. He worked about 28 hours a week. He didn't have any recreational activities, but essentially it really boiled down to the point that he didn't have any medical treatment for his continuing neck and right shoulder pain. Her Honour made the observation that the worker had retained the capacity to work notwithstanding his impairment. Although the worker had reported constant pain, he had not required medication to assist in carrying out of his work duties, nor had he sought medical treatment or complained of increased neck problems to any treating doctor since resuming work. The worker had remained relatively inactive in his home life, performing gardening and light maintenance duties, and it's important to consider what he had done about his pain. Not taken medication, as I've mentioned, and not only didn't take medication, but he didn't do anything about his sleeping problems, or did he take any medication or seek treatment in regard to that as well. An appeal Justice Tate agreed with Her Honour's reasonings at the first instance. The analysis of Haddon Engineering was endorsed, and so was the case of Sutton and Laminex, and they're cases which are the ground rules of pain and suffering, and this is another case which follows those decisions. Essentially, the judge was correct to consider all these matters, and in doing so should not fall into the error of regarding the failure to take meds or continue with treatment as in itself evidence that the pain and suffering consequences of the impairment were less than very considerable, and that's at paragraph 63 of that decision. The fact that the worker had not complained of increased neck trouble to any treating doctor since returning to work, and the nature of his sleep disturbance had not been such to require medication or treatment, and he had remained as active as possible, including potting around in the garden and doing some light home maintenance. So in those circumstances, the court held it was open for the judge to find that P&S consequences were less than serious. The next case of a borough and network personnel and WorkSafe Victoria is a decision of the 7th of March of this year. The trial judge here was Her Honour Kennedy, and she refused to grant leave to bring common law proceedings in respect of P&S. And this case really looks at the need to demonstrate intensity and frequency of pain suffered. And here the appeal was dismissed. The injury was an injury to the right hand in August 2006. He was right-handed, Mr. Barrow, and it involved pushing a cut of meat through a bandsaw when the saw connected with the inner part of his right hand and sliced it open. Again, Hayden Engineering was endorsed, Sutton and Laminex as well, and they're really talking about the intensity of the pain, what the plaintiff says about the pain. This is to both in court and to doctors, as we know, what the plaintiff does about the pain, medication, rest, etc., getting medical treatment, what the doctors say about the extent and intensity of the plaintiff's pain, and the objective evidence which shows the disabling effect of the pain. Now, statements that do not assist. Firstly, saying that the person just suffers pain is not enough. You need to talk about the intensity of the pain that's been suffered. Nor does a statement in effect of saying, look, the pain is worse in particular conditions such as cold weather. As counsel for the employer pointed out, both at trial and at appeal, Mr. Barrow said nothing directly about the intensity or frequency of the pain. And this can be contrasted with the example of Hayden Engineering, where in that case they mentioned he experienced constant pain, the pain was with him when he woke up in the morning, it got worse during the day, the pain interfered with his work, he needed to rest, the pain interfered with his sleep, wake up 3, 4, 5 times a night, and those sorts of things. You need to really go that next step forward. So in this case, the medical evidence didn't help either. So the principles in Hayden Engineering and Sutton were endorsed once again. Capacity to work was one of the matters to be taken into account, and then you're also looking at all the other factors which we know about: sleep, mobility, cognitive functioning, social activities, recreational activities, sex life, enjoyment of life, and those sorts of things. Now, the appeal submission for Mr. Barrow was that the crux of the evidence, the crux of the medical evidence lay in the reports and showed the level of pain. But that, in effect, did not happen. Just mere mentioning of a minor loss in range of movement and difficulty in straightening the finger wasn't enough. Her Honour noted that Mr. Barrow's counsel relied on a number of other finger cases, which other judges made decisions in the county court. However, all those cases talked about significant pain and constant pain. And Her Honour stated, this is at paragraph 33, in the present case there is little if any precise evidence as to the constancy and level of pain. The plaintiff also manages any pain by only occasionally taking over-the-counter painkillers. There was no evidence that the plaintiff is currently managing his work with great difficulty, for example, the access to regular medication or extra sleep. And ultimately, the Court of Appeal rejected the appellant's submissions, and the reasons for judgment failed to demonstrate a path of reasoning. So, things to consider going forward: is there evidence of significant or constant pain? I've mentioned there in the paper. Is there precise evidence as to the constancy and level of pain? And does the crux of the medical evidence really show and support intensity and frequency of the pain? Okay, the next case is the case of Buzina. And this is another Court of Appeal decision of July of 2012. This was an appeal from an order dismissing a serious injury application. and this was in relation to Section 93 of the Transport Accident Act. This was a decision in first instance from Her Honour Judge Cohen. It involved a transport accident in March 2006, an injury to the right shoulder and some neck pain as well. Her Honour dismissed the applicant's application, and essentially there was a prior injury at play. And that prior injury happened in 1999, where in the course of his prior employment, the applicant suffered a spinal injury. He was subsequently, he had significant medical treatment, rehab. He couldn't return to employment, and then he was actually put on a receipt of disability support pension because of the injuries that he received. So before the accident, the applicant had been prescribed morphine in the form of OxyContin, and over an extended period of time. And at paragraph 15 of that decision, Her Honour was quoted, "The difficulty in this case is that assessing whether the degree of impairment it causes can be fairly described as more than significant or at least very considerable when superimposed on an already very modified and limited lifestyle due to pre-existing conditions." So have a look at the before and after picture. As it had not impacted on his earning capacity, and as there had been very few changes in the mode and parameter of his activity since the accident, I am not satisfied on the evidence that he reaches that test in respect of his right shoulder. Again, this is at paragraph 23. Her Honour was bound, when looking and examining the consequences of the claimed serious injury, to look at how they affected the applicant as he was and would likely have been absent the injuries he sustained in the transport accident. Her Honour also said that she had to look at what his level of functioning was in total just before the accident and what worsening on a long-term basis has been brought about by the injuries suffered in the accident. Now, the next case is the case of Junkos and SPC Mona Operations Limited, and I understand a few of you in the audience are very familiar with this case, being one of your former clients. And this was an appeal from an unsuccessful application to commence proceeding for loss of earning capacity argument. The P&S was successful. The issue was whether the test, or whether the loss of 40% or more of his earning capacity, and there's also a second issue involving a Calder Bank offer, which I'll go to in a moment. Essentially, in November 2005, Mr. Junkos was a forklift operator. He suffered a full supraspinatus tendon tear in his right shoulder. It was surgically repaired, and then he tore it again on 2 subsequent occasions. And the Court of Appeal held that the appellant had established that the permanent impairment of his right shoulder resulted in a loss of earning capacity of 40% or more, and he was granted leave to commence proceedings to recover damages for that. At paragraphs 99 and onwards, the Court of Appeal go further and actually specify the reasons for that. The Act differentiates between an ability to earn income in a suitable employment because of an impairment and an inability to earn income because of a tight labour market. So a worker's reduction of the capacity to earn income in suitable employment must relate to the former. So we're looking at the impairment, not about the labour market. This is reflected in Section 5 of the Act, as we know, which requires the court to disregard whether the work for which the injured worker is currently suited is or not available to the worker. And these are the reasons why grant of leave was satisfied. Firstly, the worker's capacity for work, for which he is currently suited, must be assessed to the usual references. That's to his age, place of residence, his education, skills, and the like. In this case, he was 58 years old, left school when he was young, he was unskilled, and did lots of manual work, and employment was situated a long distance away from his residence. and it would not be suitable employment within Section 5 of the Act. The employer didn't contend that office work would be suitable employment. Secondly, the trial judge made no adverse findings about the appellant's credibility, and that appellant freely conceded that he could do light process work which did not involve lifting his arm above his shoulder or drive a forklift without doing associated lifting tasks. The issue was really whether any of those jobs were in existence. Thirdly, the worker's capacity for suitable employment is concerned with his or her physical or mental capacity to work again. The fact that the appellant experienced pain and suffering after returning to work at SPC followed his initial injury and was shortly thereafter diagnosed with a second tear is also relevant. Even if he did manage to find work which he could, it was not unlikely that he might suffer further injury by inadvertently using his right shoulder in a way which did not comply with his restrictions to which the medical evidence referred. Fourthly, the appellant gave evidence that he continued to experience pain in his shoulder which increased with use, especially repetitive, active and weight-bearing activity. The pain suffered by the appellant is relevant in assessing his capacity to undertake suitable employment. Fifthly, there was no evidence that real forklift and machine operator jobs complying with the restrictions which affected the appellant existed in the area in which he was living. Sixthly, if only the employer in the area which had jobs which the appellant could perform had ruled out any possibility that it would employ the appellant, there would be no work for which he was currently suited, having the factors in regard to Section 5 of the Act. And finally, this is at paragraph 115, the Act required the appellant to prove, on the balance of probabilities, that no suitable employment existed in which he could earn 60% or more of his pre-injury earnings. And the court considered that the employer bore an evidentiary onus to adduce evidence that there was no other jobs in the Marupna area for which the appellant was suited to. Overall, there was substantial medico-legal evidence and the appellant's own evidence to establish that the appellant was unable to do a forklift work or other jobs which required him to raise his arm above his shoulder. The employer also conceded that they did not want to rehire him. SPC had to advance some evidence that there was suitable jobs in existence in the Marupna area or the surrounding area, and it failed to discharge that evidentiary onus. There was no clear evidence that jobs of the particular kind existed elsewhere, and the appellant's evidence was that they did not. The second issue in this case was the issue about costs. And just briefly, leave was granted to commence proceedings to recover damages for pain and suffering, but not for loss of earning capacity in the first instance. And the respondent had served a Calder Bank letter, or offer I should say, and the judge ordered the respondent to pay the appellant's costs up to and including the date of service of that order, but made no costs after that. Now, the court held that because they granted leave for loss of earning capacity, they didn't need to actually decide on that issue. However, they felt that it was appropriate for the court to express its view. And that view is summarised in paragraph 134 of the decision, and essentially it says that the Calder Bank procedure is not required by the county court rules. The county court may not have regard to a Calder Bank offer, such as that made in this case, although it appears odd that Parliament would intend to preserve the Order 26 procedure, that is the offer of compromise, but exclude the Calder Bank procedure. That is the clear meaning of the words used, and that result fits within the legislative scheme. And finally, the last case before we break for half time is the case of Buzina and Precision Solid Plasterers Proprietary Limited. And that was an appeal due to the trial judge, in this case His Honour Philip Misso, for his reasons being inadequate. Here we had a lower back injury in November 2007. The application was made in respect of both heads, In 1997, he hurt his lower back as a scaffolder in the course of his employment, and he continued to work up until 2007, where he aggravated his back once again. After that, he did work for his brother, who ran a furniture store in Geelong, and he was employed roughly for about a month in mid-2010. And His Honour held in first instance that as a result of the work which the appellant undertook with the first respondent, especially in 2007, the appellant suffered an aggravation of the pre-existing injury to his lower back. There are two issues really in this case. The first was the appellant's employment with his brother in 2010 suitable employment? And the court held that with respect to His Honour, the evidence did not necessarily, in their view, lead to the conclusion that the 2010 employment was suitable employment. It was arguable that the job was protected employment from his brother, and there were further two significant reasons why the employment arguably was not suitable employment, and that was because there was a 2.5-hour drive to go down to Geelong for that work, and the requirement for significant standing. These matters were not addressed by His Honour's reasons. So in the Court of Appeal's view, the reasons given for the concluding that the furniture salesman position constituted suitable employment were inadequate, and at first instance the Court of Appeal had doubt that it could be said that furniture salesman position constituted suitable employment. There may be some reasonable path or reasoning. However, such a path of reasoning was not disclosed in the original decision by His Honour Philip Misso. Secondly, there was a couch incident. His Honour found that the couch incident was of considerable significance. The appellant talked about how he slid a couch along the floor and then hurt his back, and that was in 2010. The appellant's case had a couple of things in mind, but the second point was that there was, in any event, a causal link between the injury and the aggravation caused by the couch incident. Unfortunately, His Honour omitted to deal with this case of the causal link to that further aggravation in that subsequent employment in 2010. The fact that the appellant was able to perform this work after the couch incident provides an additional basis for suggesting that any injury or aggravation suffered as a result of the couch incident may not have been as great as His Honour appeared to have considered it. And essentially, the appeal was allowed and the matter was remitted for hearing and determination, which hasn't yet occurred. Thanks very much for listening.
Thanks very much, Stephen. Thank you for that interesting exposition of these cases. There's a couple of things I noticed. One is that case of Hawkins against DHL. Judge Burke decided that at first instance, and I note that the applicant was something like 72 years old, and she used the fact that he was old to say that he wouldn't really have suffered a serious injury because the duration of his injury wouldn't be particularly long because he was so old. And the Court of Appeal, which is really a reverse of what is usually said, a young person may have an injury that's not so significant, but the duration is a factor in weighing up its seriousness. And I think the Court of Appeal said you can't really do what she did, the opposite, and say because they're old they're not going to be suffering for too long. But I think they found that that didn't vitiate the validity of the rest of the findings. And the other thing was, in that case of Giancos, it was interesting the way the Court of Appeal dealt with the onus being on the defendant to show an evidentiary onus to adduce evidence there are other jobs in the Mooroopna area. I think the court said effectively that there was an onus on the plaintiff to show that his injuries restricted him from doing the sort of work he'd been doing before, and he having adduced evidence that SPC would no longer employ him and that there was no suitable work at SPC for him to do, there was a shift in the evidentiary burden for them, then the defendant, to show that there was no other suitable work for him in the area, and that's probably a little bit unusual because Mooroopna is not such a large employment catchment area as the metropolitan area of Melbourne. Okay, now I think we've got time. Do you want to have questions now? Or why don't we do questions now while it's all fresh in your mind? If you're like me, you'll forget some of Stephen's words of gold after the next speech. So if anybody wants to ask some questions, we'll have a few minutes now.
With the matter of Giancos, Stephen, and the Calder Bank issue, if reading from that, if an offer of compromise was made, the court would have accepted that.
It's essentially, yes. In the rules of the county court, it allows offers of compromise, but it does not specifically allow for the Calder Bank offers or letters. So in that regards, yes. The answer to that is yes. And they're waiting on Parliament to change or make any changes to allow Calder Bank offers to be accepted. I know it sounds pretty weird that you can have one, not the other, but because of the rules and because of the sections of the Act that actually refer to in the decision, it's very specific.
Although I'm thinking, I take it from the date of this judgment, this was a pre-fixed cost order application. Now under the fixed cost orders, I don't think an offer of comp would even be valid.
I'm not sure of that question, and I'm not actually sure when this actually was started. I know the decision was on the 5th of May 2012, but essentially, I suppose the work cover cost litigated claims order does cover most things in these days, and everything going forward from now, that's what you should be looking at. Obviously, if you've claimed for both heads, you only get up on one of them. Obviously, there are cost implications and consequences there. But the important thing to mention here is if there are any Calder Bank offers or letters, not to just disregard them, but because of this case, you'll know that you shouldn't have to be too wary of them. But if an offer of compromise is given to you, then think very carefully about what your steps are going forward. Harry.
John, I think the equivalent in the legal costs order would be the notice that's provided for within the order itself. So the offer of compromise can't have any application.
Okay.